it's Connecticut car accident attorney Ryan McKeen here. And one of the things that I'm frequently asked is, if I hire a personal injury lawyer, is it going to get me more money? Sometimes our clients receive lowball offers early on from insurance companies, and they're worried that if they hire a lawyer and the lawyer takes a third of that, that they're going to get less money. And that's a very understandable predicament. I mean, I knew before I was a lawyer, I was in a car accident, and fortunately, I had a lawyer that I knew I could trust through my family. So today, what we're going to really talk about is I'm going to give an example case, and every single car accident case is different. No two cases are alike, but really, any experienced Connecticut car accident attorney should only be taking cases that are going to result in getting you more money. And I mean, sometimes if somebody came to me and said that the insurance company has offered so much money, and I reviewed the case, I've looked at the meds, I've talked to them, I have told them in the past to accept that because it's fair and full compensation, and I'm unlikely to do much, if any, better. So today I'm going to talk about a case, and I'm going to not mention the case by name, but it's a case that I handled and that I litigated. This is a case where our client was rear-ended on a highway by a driver that was not paying attention. And when this accident happened, like many of our clients, the client went to the urgent care to receive some treatment, was basically told to go home, to take some Tylenol, some x-rays were done, and all told, the client had $3,000 in medical bills. Now, sometimes people will say, they think that there's a formula to a personal injury. Maybe they think that a settlement should be 2 or 3 times medicals, or 4 times, or some multiplier of what the special expenses are in a case. And that's not true at all. I mean, every case is different. There are factors that drive value or detract from value in every single case. But in this case, the client had approximately $3,000 in medical bills. And early on, pre-suit, before we filed the lawsuit, the insurance company didn't take it very seriously. And they had offered us $7,500 to resolve this claim. And I looked at the file, I looked at the medical records, I really listened to the problems that my client was having, and really got to understand. I talked to some coworkers, some family members, and really got a picture of how this accident had impacted our client, both personally, professionally, the things that the client was unable to do that they used to be able to do, like go for long bike rides and work out, they were unable to do because in the accident they suffered a concussion. Now, brain injuries, there's oftentimes in cases where somebody has a concussion or has a brain injury, there's often very low medical bills because in these cases, they're not going to operate on you because there's nothing surgically that they can do. Generally, cases with lots of medical bills are orthopedic cases where there is surgery, there is imaging, there is rehabilitation from that surgery. But with a brain injury kind of case, there is not surgery. There's not usually extensive medical treatment or drugs or therapeutic treatment that is given. So after listening to our client, I knew that the case was worth much more. I knew that the insurance company did not understand the value of the case. They didn't see my client. They didn't know my client's story. So what I had to do is really work to make them understand that. And when I understood the consequences that the client was suffering as a result of this collision, what I did is I worked with the client to find some of the best providers around, worked with the client to get imaging in New York City, to meet with neurologists, to meet with neuropsychologists, to help get some of the care that the client needed that they weren't getting from their primary care doctor, that they weren't getting from an urgent care, to try to help get better. And through connecting the client with these really skilled doctors, they were able to do some imaging. And the imaging done in Manhattan through a machine called the DTI was able to show white matter changes on the brain as a result of the car accident. And that got the attention of the insurance company because it was something really objective that we could point to say that this is the visible impact that this collision has had on my client, which explains all the other symptoms that my client was suffering. Because what the insurance companies want to do is they really want to say that the client is a liar, that the client is making this up. And I knew that that wasn't true. I knew this person's work ethic. I knew their physical activity level prior to the accident. I took the time to understand that, and I knew that this client was not faking this. Really, none of our clients fake injuries. That's something that the insurance companies make up, but it's really something that we have to deal with. So once we had the imaging in place, we were able to really find really the right neuropsychologist to help document the limitations, to help come up with alternative treatments so that the client could resume work, where they can, they're given therapies on how to do things differently, how to organize their day differently, to make modifications, to make things better for them. So really, through the combination of helping the client get to the right doctors, to get the right treatment, I was able to talk to these doctors and get them to write reports on our behalf. And the reports really detailed the impact that the accident had and what the doctors thought was necessary for future care. And mind you, prior to doing this, we had a $7,500 offer on the table. So we got the reports, and what I did is really, I interviewed the client. We made a video for the client trying to explain in the client's own words, because I knew my client would present very credibly, the impact. And after we sent these things over, the insurance company said, whoa, okay, we've reevaluated this claim and we want to discuss this matter with you. And that happens a lot in these kinds of cases where insurance companies they initially assess a claim to be one thing, which may be a low multiplier of medical bills. And the reason why they do this is because they want to see if a client wants to take, quick money. There are people out there who are very desperate for money in today's day and age. And so maybe getting $3,000 or $4,000 that week makes a big difference in them being able to pay rent or afford groceries or afford medical bills or, pay for the many expenses that their children have. So that's why insurance companies commonly make that initial lowball offer. And they're also, insurance companies know that if a client accepts these offers, that they are going to buy out of a lot of liability on their end, because once the insurance company has a release from somebody, then the claim is really, really over, and anything that happens after that, they're off the hook for. So they really want that release, and that's why they send over these lowball offers. Well, the insurance company then tried to negotiate with us. We ended up having a pre-trial with a judge, and I stuck to it. I said that this case is worth every single penny of the policy. And we're not going to move off the policy because we think that the damages here, in fact, exceed what the insured's policy is. And so we discussed with the defense lawyer that we may file a prejudgment remedy. And what a prejudgment remedy is Connecticut has a special procedure where you can go to the court and say that the insurance company, the amount of insurance is inadequate to satisfy the claim. And you can say, I'm going to prove that to you, court, and I'm going to seek, contribution from the insured for the amount over the policy that the court finds as reasonable damages. And practically, this puts a lot of pressure on the insurance company because they have a legal obligation to pay claims and to pay them fairly and to protect their insured from personal exposure. So the person who caused the accident, if the insurance company can protect them, they have an obligation to do that. And the way in which that they can do it is by tendering the policy. And if they don't tender the policy, what can happen to them is it can do what lawyers call opening up the policy, which means that the policy limits are no longer material, because if we get a verdict in excess of the policy, then what happens is it becomes uncollectible against the person who caused the accident, and their claims against the insurance company for bad faith get assigned to our client, and we can then pursue the insurance company for failing to settle the claim and oftentimes get double or treble damages. So this is a big consideration, and any Connecticut personal injury lawyer should be very familiar with the prejudgment remedy statutes. They're very technical. They require technical filings, technical proof, special hearings, a trial. So you really have to have your ducks in a row before you bring one of these kinds of claims. And we discussed this with the judge, we discussed it with the insurance company, and ultimately they came around to seeing our point of view and seeing that it was best for them in their interest, in the interest of their insured, to settle the claim for the $250,000 policy. So look, every single claim is different and every case is different, and you should have your case evaluated by an experienced Connecticut car accident attorney before you settle the case, and really that attorney owes it to you to be honest and say, look, this is worth more or not worth more than the initial offer. Again, the initial offer here was $750, and the case ended up settling for $250,000. Now, just because that happened in one case doesn't mean it's going to happen in your case. All of those disclaimers, but really a personal injury lawyer who works your case, who understands medical bills, who takes the time to understand your story, who knows who the good experts are, who can document this, who can afford to hire those experts, can add value to your claim, because when you combine those things with litigation skill, with trial skill, and a willingness to show the insurance company over and over, claim after claim after claim, case after case after case, that you're not going to accept lowball offers, that you're going to seek full value for the policy, then really and truly a personal injury lawyer can add value to your case. So if you have a case and you're on the fence about hiring a personal injury lawyer, whether you're talking to me or somebody else, I think you should really be asking them, what might this be worth it? And it might be a hard question for them to answer, but in terms of some ranges, you need to be talking about the insurance policy limits, you need to be understanding what the medicals are, how the injuries can be proven to be related to the accident, and really what the future impact is. So there's a lot of understanding, and then a good attorney is going to be able to tell your story, advocate for you to a judge, to a defense attorney, maybe to a jury, to get you really the fair compensation. So again, please, if you're out there and you've watched this far, make sure that you get your claim evaluated if you're on the fence. Through me or my colleagues, there's no charge for a consultation. We're here to look after you, to really look at your claim, to see what it is can be done. And really look for an attorney out there who's experienced, who's going to tell it to you straight, and is going to take your case and do a good job with that. If you have any questions, don't hesitate to give me a call, 860-471-8333.